Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm here with my friend Schnitzel Ninja, who just spilled a bunch of food on herself and water.
Water from Lauren's a joke.
Yeah. I don't remember which one it was, but yeah.
I don't either know, but it was good.
Anyway, sorry we're late. It was her fault, obviously. And
I'm pregnant.
not what? I didn't do that.
It's from the water.
Oh god. Okay. Well, anyways, it's again, sorry we're late, but it is only noon here, so I figured you guys could suck it up. And by that I mean I was shoving food in my face and I had to finish that before we could do this. Anyways, let me pull up. So this arraignment thing happened while I was on the plane. And it was kind of uneventful. I'm told. I don't really know. I haven't been able to see much because I couldn't even load YouTube or anything on the plane. I was literally just like sitting there mindlessly for 15 hours. So it was pretty much a typical Thursday for me. Yeah. Anyways, so that did you guys actually watch that while it was happening, or how did that work out? 'Cause
Not
I didn't
while
know
it
how
was.
that.
Yeah, not while it was happening. Bianca Buono had posted it. I think it was on X. I got the YouTube link to their video, and then there's also another video that is the coverage, but it's like a different. They use. I can send you the other link too. But yeah, so once it became available, we watched it on Megan's.
Gotcha. Okay. I'm just like really curious about the distribution that they're doing or whatever. The court. I mean,
Yeah, I'm not sure about that.
yeah. I knew that News 12 had asked about pool camera and shit, but I didn't know. Anyways, I think I'm probably gonna go to. I'm gonna probably go to the like most of the hearings.
Nice.
So I'm not gonna worry about that, but not to stream or anything like that. Just to fucking be there, you know. Anyways, just Ricardo. Let's see. Thank you for the 2. Don't get in trouble abroad. I did not agree to that. So. I don't try to get in trouble. Okay, I just
do.
I say things. I say things.
Oh, that was so funny.
Yeah, great. Fake Laura Owens, thank you for the 5. Suck it up. That's how I got here in the first place. Oh. Thank you, fake Laura Owens. God. All right. We were warned it could be boring, and it was. So okay, so I guess it really was that boring. Okay. Anyways,
Yeah.
I wanted to talk about what her lawyer said after, but let me pull that up while you were gonna say something. Hold on.
Oh no. Me?
Yeah.
Me? No, I don't know.
Oh, who else were we talking to? Hold on. I'm trying to find this. I'm woefully unprepared.
Here, I'm sending you a couple links in the private chat.
Okay. I got this one.
Okay. Oh, I was just looking for that one. So the one that I just said, the first one I sent you is just the regular stream that they shared. And then this one is where they interview her new attorney.
Yeah, okay.
And then I sent you a Jimmy Jenkins article.
Oh.
Wait,
I only got one.
It's a one 2 girls, 1 cup. It's 2 links, 1 message.
I have like such a visceral reaction to that. It's like my automatic response is to cringe. Please no, none of that. Oh my god. Okay.
So there are 2 links in that message.
All right, I got this one. Yeah, we'll do this first then. Okay, Laura Owens has pleaded not guilty to criminal charges stemming from a judge's determination that she gave false testimony about a pregnancy involving a former contestant on The Bachelor. Right, you know that. The paternity suit judge found Owens had altered documents, changed the results of a pregnancy test, given false testimony, and potentially perjured herself, appearing to have created, the judge said, a case of serial fabrications.
So why the one thing I don't like is that anyone who covered this recently, I'm glad they're covering it, but no one talks about the scheming, which is the class 2 felony.
Yeah. I don't know.
Yeah, maybe they don't know exactly how to
cover that. It's a lot to take in, I feel like, if you're not doing it from the beginning. I mean, that's why I won't touch stuff like Karen Reed or even Hales or anything like that. I'm like, I wasn't here from the beginning, and I do not understand this tsunami of information that you're trying to give me right now. So I quit. So I don't know. I mean, maybe it's just like that. But let's see. These allegations appear to be the result of coordinated harassment, misinformation, and public pressure in the aftermath of a paternity case I filed against former Bachelor star Clayton Echard, Owens said. Was that her press release?
I don't know. Probably, but I couldn't say for sure.
Owens appeared remotely on May 29th. The judge entered a not guilty plea for Owens and released her on her own recognizance without a bond at the request of her attorney. The judge ordered Owens may not leave the state without permission, so no going to Planned Parenthood in California. A pretrial conference was scheduled for July 11th with a tentative trial date of October 23rd, which I think some people were saying is probably most likely going to get pushed.
Yeah, I've been feeling the same way too. I feel like they rarely happen on the originally scheduled date.
Right. Yeah. Okay. Let me we'll skip ahead to where he's talking pretty much. Let's see. On this one. Because I had never heard of this guy, obviously, until today. And I don't have anything, I'm not here to like knock that guy or whatever, but his statement actually like irks me so much. And I know he's doing his job, so I'm not here to like bag on the guy. You know what I mean?
And I want to, can I say too, like, I think we can lay off like making fun of how he looks.
I mean,
it's happening, and we don't, just because he took her on as a client doesn't mean he's like a total piece of shit. And so I think it makes us look bad as a group if we're already like ragging on, publicly on how he looks.
I mean, I try not to. I'm just, I can only tell people what I think and what I'm going to do, which is not, I'm just not going to bag on the guy. But still, I think people will do what they want. So all I can tell you is what I think, which is I don't really have any feelings about the guy. So, Yeah. Okay. Let's
Accused of altering an ultrasound image, lying under oath, and fabricating a pregnancy video as part of her alleged scheme. Her defense attorney says wholeheartedly that she disputes that and says the indictment came as a surprise to her.
Her entire life has been turned upside down. She feels like she is unjustly accused, and she's trying to fight and get her name back. And on top of that, she's facing a significant amount of time incarcerated.
I mean, that's kind of how it should be, though, yeah? So, yeah, like I said, I have nothing against the guy personally. Just the statement itself is kind of like, it turned her life upside down. She's trying to fight and get her name back. And I'm like, dude, like, she did this to so many people. So there's no way to hear that and not be like a little bit angry, just at how she's acting outraged and in the face of everything that she's done to all these people.
Yeah, it's like I feel like being a lawyer would be like, aside from other things, would be really tough because of that. Like, if you take a case on you, it is your job to defend that person.
Yeah.
Even if you think they're a piece of shit, even if you think they might be lying, you're still being paid to do what's best for them. And I would find that very difficult to do. I think I would have to work more for like an advocacy group that's like, I don't know, you can do the research into the case and decide if you want to take it on because you believe in it, kind of thing. So I would just personally find that very, very difficult. And we have to remember too, like, and I don't know how long they've had with her. How long has she had them retained for?
Oh shit, I have no idea.
And maybe not that long. So maybe they haven't had so much time to look into the case.
Like
but
anyway,
like, he's not gonna say like, oh yeah, well, she did some bad things, so we're gonna try to get her the best deal. Like, he can't say that. So
nobody's gonna give a David Gingras level monologue in this game. That was a special circumstances. I feel like
yeah,
we were a little spoiled with that.
Spoiled
in the worst way possible. But I mean, it was terrible, but the things that he was saying and doing, but at the same time, it was fucking hilarious. So I mean,
yeah, I know, and yeah, just that whole thing. I know I say this a lot, but just to think that those two found each other, like how different this would have been, and how maybe she wouldn't even be being charged right now or investigated.
I don't know. He seems to think that as recently, sorry, I cannot speak right now because I'm so tired. As recently as like 2 days ago, he still thinks that if he had been involved in the beginning, this would have turned out differently. But then he would not be able to ignore all the things that he's ignoring. So that
I think she would have been worse off had he been involved earlier on.
oh, for sure. Yeah. Omar said her new lawyer should insist she cut off Jingris. Oh my god, I cannot talk right now. I'm sorry about that. I don't know what my problem is. I'm so whacked out of my mind with these time zone changes because I went to California, right? And then I got used to that. And now I'm here. So, and now it's tomorrow where I am. So I don't know what's happening to my brain. But I'll get over it in a day or two. So, all right. When did he say that?
In the role play I did with him a couple weeks ago.
That's right. You did a role play. I forgot about that.
We
He
did.
told me you guys were role playing. I was like, I'm getting baked. So I remember jumping into that one for like 10 minutes. And I was like, yeah, I gotta go. Yeah.
That's right.
I don't do role playing. He's like, you can be who do you want me to
Jan.
be? Yeah, you can be Jan. It's like I'm not there yet.
I didn't even want to be Laura. I didn't. And
really, I figured you would have picked that.
Well, no, I mean it was an hour before, and he was like, "Hey, you got to come on and do this role play," and I was like, you want to ask Megan? He's like, well, she's sleeping, and like everyone else is asleep, and I guess I don't have to do it. And I was like, oh, come on, I'll do it. Yeah. I will do it for you.
I really thought it was your idea, but
no, 100% not.
I mean, I guess it could have gone either way. That doesn't make sense between the two of you. So.
I thought it would, like, I mean, I think, I guess it was good for him to, you know, even I guess for him to say, like, if he were with someone like that in a legal situation, how would he handle it? But also I think it's good if he, you know, just said, well, this is the advice I would give her. Like, knowing all this stuff, this is what I would say.
Okay. Hold on. Speaking of David, give me 1 second to pull this up. This is like the last thing I wanted to look at. Okay. So naturally, he's going to do his swan song via YouTube video. So that's oh god, it's been a long time since he, you know, did one on his own. I feel like, or with Laura, even, and it's been so peaceful. I don't know,
right?
Oh god, I can't. Even the thing with Rachel and Steve, it was like, this is so hard to watch right now. I couldn't watch. Yeah, I couldn't watch his videos after sometime after he was like threatening to sue me, and he did like a whole fucking thing dedicated to it, and I was like, you know what, I can't listen to this anymore. So I would only read the transcripts or like whatever was recapped on Reddit or wherever, and then of course he tried to subpoena the Redditor, the Redditor's identity, because that's a normal thing to do,
right? Denied.
Yeah, well, whatever happened with that? I think it just went away, right? He didn't.
I don't know what the statute of limitations is for him to follow up on it, but Reddit refused to comply.
I remember that.
Yeah. And so then as far as I know, and maybe that user knows more, but as far as I know, that's where it ended.
Yeah. Okay. For now, this is officially my last filing for Laura. Wait, for now, or this is officially which one is it?
Unless they accept review.
I'm starting to feel like I did in the customs line. Jesus Christ. Something bad is coming on. We have to wrap this up quick. All right. Fake Laura Owens, thank you for the 5. I'm really good at role playing, pregnant with twins, crazy lady DV survivor. Well, I would agree with that. Thank you.
Multi-talented.
Maybe we should have had fake Laura Owens role play with you and Omar.
Oh, heck yeah.
You can be Jan, and I'll just watch.
Honey, he's a joke.
I could be the dog.
Just pee on the floor.
Absolutely. You get me.
The ghost of the cute little white dog.
Oh yeah, yeah, true. That one wasn't buttons though, was it?
This new
Which
one
dog was it?
wasn't. No, the one from the Christmas video wasn't.
Yeah, which one was? Which dog was that? Do we know?
Ah,
Some random dog?
I did a slow motion of the of her saying the name, and I can't remember what it was now.
It doesn't matter. I'm just scatterbrained right now.
Misty, maybe something like that.
We'll go with that.
Let's go with Misty.
Yeah, trapped. Never mind. Anyways, I'm not gonna say that out loud. Apparently, I've regained some composure, but they did name a feral cat after me, so I wonder if the cat's dead.
It's
I hope not. She probably killed it.
She's plotting some things.
I mean, you could be joking or you could not. I'm concerned.
Well, I shouldn't say more. That's all I'll say.
Okay.
You'd think I was the one time traveling here.
Yo, everybody's in outer space to me right now. Yeah, I think I might need to sleep this off a little bit. Because I am not feeling too good as of 15 minutes ago.
Like right as
I
you're
swear
about
to
to
God,
start
I was like, I was okay. And then we start, I think it's because I just ate for the first time in like 12 hours.
Oh, yeah. Oh, I bet.
Yeah.
Yeah, I bet you feel so sleepy.
I
from
fucking
that.
do, man.
Yeah.
Yeah, I really
Well,
do.
let's
And I walked around for like 2 hours before because I got here really early in the morning. And so then I was just like walking around the harbor and nothing was open, of course, because it was so early. And so I was just walking in circles. Like around. I was like, oh, there's that. Can't go in there, but there's that.
Is the weather nice at least?
It's cold.
Yeah.
You know, it's not Florida summer here.
Right.
For sure.
For sure.
We'll see how it goes. I have at least one pair of longer pants. So I should be fine.
Is it the prison pants?
I packed jacket. I packed a jacket.
Jacket and pant.
You know, it's gonna go how it goes.
You gotta take the prison pants.
I actually forgot them. I should have though.
Man.
They have a hole in them now.
Oh, why?
I was trying to cut the tag off and I cut the pants.
Oh, that's right.
Yeah. Wait, did I tell you that?
Yes. No, well, yes, and yes.
Technically.
I'm watching you right now.
That's a little creepy.
It is.
Thanks for making
I
me
get to sit back and watch everyone.
Yeah, I kind of miss having the camera off.
People went camera off in solidarity with Laura earlier, and then I said maybe I should turn mine on.
Oh, that would be. Maybe just like don't tell anyone if you ever decide to do that. Don't tell anyone and just like make it look like an accident and then freak out.
Yeah, right.
People respond.
I should make the face I made in the picture I just sent you before the stream.
Let me get a look at that again.
I think it's pretty pleasant.
Yeah, that'll do it.
Yeah, that's a good one. I'll keep it in mind.
All right, guys. I think that's all I got in me today.
Wait, do you want to watch? It's only like 2 minutes long. The actual video of the hearing.
Yeah, we can. Give me one sec.
It should be that first link I sent.
They're all the same to me at this point. My God, my brain hurts. Okay.
Laura Michelle Owens, 5/14/1990.
Thank you. Counsel, would you please announce?
Yes, thank you, Judge. Matthew Smiley for Joshua Coleswood for the defendant who is present via Teams.
Thank you. Counsel, do you waive a reading this morning?
I do.
Court will enter.
Nicole Northup on behalf of Ed Leiter for the state.
Oh, thank you.
Okay, the one dude, the first dude that talks, sounds like the Vulture from Brooklyn Nine-Nine. I'm not gonna be able to get that out of my head.
This morning, court will enter pleas of not guilty on behalf of the defendant as to all counts 1 through 7, noting that this is the initial appearance on each of those counts. Court dates will be set as follows. Initial pretrial conference, July 11th at 8:15 with Commissioner Garfinkel. Comprehensive pretrial conference, August 11th at 9 a.m. with Judge Reader.
Sorry, still on a little bit of a brain delay here. Did somebody say Commissioner Garfinkel?
Yes.
Just checking.
Final trial management conference, October 16th at 9 a.m. with Judge Reader. Trial assignment is October 23rd at 9 a.m. before the master calendar assignment judge. Current last day is November 25th. Court needs to set release conditions on these matters, or I'm sorry, on these counts. I'll hear from the state first.
Judge, she's OR right now, is that correct?
There have been no release conditions set, so she's responding to a summons.
Okay, the state would ask that she be released to pretrial services.
Thank you. Counsel?
Judge, she's responded to the summons. I don't believe she has any prior criminal history. We'd ask for OR release.
I mean, maybe not a documented criminal history, but
So
The defendant will be released on her own recognizance.
what's up?
keep going. I'll say it after.
Ma'am, what that is your promise to attend all future court hearings. You don't need to post a bond at this time. However, if you fail to appear for any of your future court hearings, absent good cause, court could issue a bench warrant for your arrest and require that you post a bond if you are taken into custody before you can be released. Court will also order that you not initiate any contact with any alleged complainant or witness. You're not to possess any drugs without a valid prescription. Do not drive a motor vehicle without a valid driver's license. You're not to leave the state, at least not without permission. You need to continue to provide the court with proof of a local address, continue residing at that address. Looks like you've already taken care of your fingerprints. Counselor, is there anything further from the state,
No, Your Honor, thank you.
from the defense?
No, thank you, Judge.
All right, thank you. Ms. Owens, you're free to disconnect.
Thank you.
I wish she would. All right. Bruce says when they were sending her to OR, I was worried they were sending her to Oregon, and I was going to have to put her in my guest room. Wait, I wanted that guest room. Actually, I was.
You
gonna
can
stay in the
share.
barn.
In the barn.
Yeah. So.
I'll be with the chickens or the roost. Yeah, the chickens. I wanted to say just for everyone, like the pretrial services, of course, that would be part of what like bond would come from, but it's tasked with gathering information and making recommendations to the court to assist in determining whether to release an individual and what conditions would be on the release, if any, to be imposed. So that's what the pretrial services is that the state was asking for.
Bruce says the guest room is always ready for you, Lauren. You're only saying that because you're moving out of that house.
There's room on the van.
Your van.
Oh, good. And he's just like 5 hours into a trip, and you're like, peekaboo.
It's me,
From the
Laura's
bathroom.
dog.
You just go flush the toilet. It's like, what?
Oh my god. I forgot that there are toilets in those things.
Yeah, and you have to like empty them yourself, don't you? Like take it to a
Bruce.
place to get it emptied. I don't know.
Yeah, I'm gonna say no to that, but
Bruce would
more
know.
power to you if you can handle it. So yeah.
So for this case, we have July 11th is the pretrial hearing where her lawyer and the state's lawyer will talk with the judge to determine things about the case. The steps moving forward. She has the opportunity to take or make a plea deal anytime between now and then, and after that until the trial. So I guess the next thing coming up is to see Gingriss's filing to the Supreme Court.
Yeah.
Also, we still have to see, I guess maybe once that's settled too, family court wise, how they're going to tackle collecting fees.
Yeah.
So I have to see what that whole thing looks like.
Did we talk about where the money for this attorney came from? I feel like we asked that.
Well,
today, but
I think we all know.
I mean, everybody's gonna say the GoFundMe, but
Yeah. No,
is
no, but
is that something they might look into at some point? Somebody might look into at some point to make sure it's being used appropriately.
I don't know. I don't know about that.
Yeah, that shit works.
You know, it's hard to say. And I mean, she's probably gonna say it's like her rich uncle, you know,
Rich
who
uncle.
donated the money. Jam's
Oh,
brother.
maybe her godfather, Gavin Newsom, or whatever. relation he
Well,
was.
her supposed godfather is passed. R.I.P.
What was the relation to Gavin Newsom again? I can't remember.
She claimed that it was Sarah's godfather and that Bob
There we
Saget was her godfather.
Oh, Bob Saget. That's right.
Yeah.
Okay. Poor Bob Saget, if that's true.
Yeah. I kind of doubt either of those things are true, but
There's no way. That's the thing.
yeah. So yeah, I wonder. That's a good question. If they, if she claims she can't pay Clayton's fees, but then she's able to pay the retainer for this guy.
Yeah.
And I'm sure. I feel like I can't say I'm sure, but I feel like with a criminal lawyer, it's not going to be a Gingras situation where it's like, oh, like I'm going to do this really reduced price for you, and then I'm going to do this for free, and I just don't think that's the situation she's in.
Mm-hmm.
So
yeah, how much something like that normally cost? You think?
Well, I got from someone anywhere between $50,000 and probably $100,000 for a retainer.
Yeah, see, I'm asking not because I give a shit about Laura, but because I do think I'm going to get arrested at some point. There's a non-zero chance of that. Hopefully, like not until after I get home. I'm so tired.
Oh my god, go to sleep.
I will, but then I gotta go. Well, I don't have to. I guess I could put that off till tomorrow. I literally could just sit here and sleep, but then I will be like this tomorrow as well. So
If you sleep now, you'll feel like this tomorrow too. You think?
If I sleep too much right now, yeah.
Mm-hmm.
So I'll have to figure that out.
That's tough. Do you know when your sleep cycles are? Like,
lady, I don't have a sleep cycle anymore.
it's just asleep.
I'm getting out of bed at like odd hours of the night to check court websites, and that's my life now.
Yeah,
because I do my real job during the day, which still sucks, and but it's very easy. So
the trade-off.
And then I sometimes nap at 5 p.m. I eat probably twice a day if I remember. It's a mess. What were we talking about? Sleep cycles? Okay.
Yeah. Well, I was just thinking if like if you're usually an hour and a half when you usually would end up like waking up or coming out of the deep sleep, maybe that would be a good time to end the nap.
In this situation. It's no.
Well,
there's no usually anything. It's just.
I will say good luck to you then. Whatever you do.
Yeah, that's probably the right thing to say. All right. I'm gonna go crash.
Okay.
I could make it 5 feet to the bed. But thank you for this. I will talk to you some more later. It's gonna be really weird.
Yeah, Gingras
he
dropped
really
this
just
video
right now. Fuck you, David. Oh
my god. It's 26 minutes long.
Damn it, David.
Do you have the link?
Do I have the link?
I just sent it to you.
The willpower? All right. Ah! Sorry, his voice.
I know, it's like very boomy in my ears. I want to get out of my body, please.
There was no, I can't show his shit on my streams, so let me bust out the transcript here. Oh, it's not processed yet, but I'll click on the thing. We didn't have to watch this. Oh, shut up, man. I realized I clicked on your video, but please shut your mouth. Okay, we can. Oh, fucking hell! What? I'm not going over 270 pages right now, man.
What?
0 chance.
Oh, it's this thing. What? 271 pages?
What a fucking mess.
I bet a lot of it's quote unquote evidence.
I hope so. Hang on.
He probably has a word limit, and then maybe can attach like supplemental materials.
All right, hold on. Yeah, you're right.
Did he link the document?
What the fuck is this? Hold on. Hang on. Fucking. 1 sec. What the fuck is this? What is this? Have we seen this? Yeah? No?
Wait, what? I don't think so. I think this is what he just submitted.
Oh my god, this is like a fucking burn book. What is this?
Oh my god, do you think we made it?
No. No. It's just Dave and Megan.
Yeah, a lot of it
Mention
is like
relevant
these
information is
exhibits.
right here. Jesus fucking. Okay. This is so insane. Can you imagine if there was a line about a schnitzel ninja in this?
No. No.
Holy fuck.
So up to page okay. Good. Wait, that's a good faith certificate. That's a verification. So his conclusion, it looks like, what's that page 188? Oh, that's exhibit D. Okay, hold on. Yeah, so much of this is just supporting evidence.
Okay.
And the court transcript, which is really long. Exhibit B, exhibit A. Okay, so his thing ends on page 20.
Okay. And then what is all this shit?
Just exhibits.
But where are they from?
Lots of things. Like, yeah, it's basically the whole case and like specific filings.
Okay, because I did not think I had seen that weird paragraph about Dave and Megan before, but
No, that's part of his document.
is it? Because I saw it way down here.
Oh, you did? I saw it at the top, I
I
thought.
sworn I did. Hang on. It's down here somewhere. You know how my brain is right now, though, so I could be absolutely wrong about this. What the fuck? What was that?
Oh,
Wishing a
number-
happy and safe 4th of July to everyone but Laura Owens and David Jingers.
Yes, isn't this her declaration?
I think so, but I just
Oh,
forgot
it's his affidavit.
No, here it is. That's what I was seeing on 241.
Yeah.
Okay. Fine.
And that was filed July 8th, 2024.
Kill me.
Bruce wrote as Jingris, like he wrote in here, Schnitzel Ninja called me a dingus.
Jesus. Yeah, I should go to bed.
Yeah.
I should go to bed.
Are you gonna do it?
Are you?
Probably not. Yeah, I'm probably gonna watch this dumbass video.
All right, then. Let's start reading. I'm not going to bed without you.
I will read it if you want.
Yeah, I was actually gonna demand that. So thank you. You need me to zoom in? Are you good?
That's good.
All right.
Introduction.
Let me move our heads real quick. There we go.
Oh, nice. From 2006 until 2019, sanctions in family court were controlled by Rule 31 of the Rules of Family Law Procedure. Rule 31 prohibited groundless pleadings like yours, and it allowed courts to sanction violators. The rule had no prerequisites before sanctions could be imposed. No warning was required, and once a violation occurred, that was it. The violator could not escape sanctions by withdrawing the offending pleading. Rule 31 was simple, clear, and harsh. It was also old and outdated, like me. As Jingers. Okay, to keep up with the modern standards in 2018, this court abolished Rule 31 and replaced it with something new, Rule 26. Oh, you know who else helped with that? Greg Woodnick. Like Rule 31, Rule 26.
I heard that guy's a liar.
He lies. Rule 26 still prohibits groundless pleadings, but unlike Rule 31, Rule 26 contains new procedural safeguards which must be met before sanctions can be imposed or even requested. This brings us to the heart of the problem in this case. Petitioner Laura Owens, period. Yes, that's the heart of the problem. Was sanctioned $150,000 for filing a pleading in violation of Rule 26, but the trial court followed none of the mandatory safeguards of Rule 26. Instead, the trial court utterly ignored Rule 26. Instead, In substance, the court followed the old abrogated standards of Rule 31. This error was clear, plain, and egregious. This court has never interpreted Rule 26. The time has come to do so. This case presents a perfect opportunity for the court to provide clear guidance on this important new rule and name it after me, please. In doing so, this court can help all Arizona family courts and lawyers understand change may be hard, but it is sometimes necessary. Like Laura Owens should stop fucking lying about shit and pretending she's pregnant. Change is hard, baby. You can do it.
What line was that?
Oh, it's like a hidden
Kidding.
ink or something.
Don't answer that. Go ahead.
Issues decided by the Court of Appeals and presented for Supreme Court review. Can you scroll?
Yeah. Sorry, it's taking a little more effort than usual. Jesus Christ, man.
Issue 1. Can a family court impose $150,000 in sanctions for a violation of Family Law Rule 26, the family court equivalent of Civil Procedure 11, without following any of the mandatory safeguards in Rule 26C, prohibiting sanctions unless the moving party first personally meets and confers, followed by a written warning and a 10-day period within which the opposing party may withdraw or appropriately correct the alleged violations? Issue 2. If a party is threatened with sanctions for violating Family Law Rule 26, and if the alleged violator responds by invoking the safe harbor of that rule by moving to dismiss the offending pleading with prejudice, can the family court refuse to allow the pleading to be withdrawn and then impose $150,000 in sanctions for fees incurred after the violator moved to dismiss the pleading with prejudice? In other words, when a party is accusing of filing a pleading that violates Rule 26, can a family court block that party from invoking the safe harbor and then sanction them for the...
I just zoned out
Scroll.
so hard. I'm sorry. Okay, go ahead.
It's dumb. Don't worry. You didn't miss anything.
No, that's why I zoned out. It's like white noise.
The same pleading they attempted to withdraw. Do you want to check your super chat?
Oh yeah. Sorry.
That's okay.
I'm like slap happy right now. Jim, thank you for the 10. Thanks for staying awake and giving us Jingy's message. Enjoy your trip. Thank you very much. I appreciate it. I will not be thanking myself for staying up, but so thank you, Muppet. There's another Muppet.
Thank you, Muppet.
They're all Muppets now.
Yeah, I know. I see so many Muppets.
God damn it.
Muppet mania. Issue 3. If a party is accused of filing a pleading in violation of Family Law Rule 26, but the procedural requirements of Rule 26 are not followed, can the trial court fix the defect by using other authorities such as ARS 25-324 and or ARS 25-809G to punish the same Rule 26 violation in a manner that does not comply with the safeguards of Rule 26? In other words, does Rule 26 provide the exclusive remedy for a violation of Rule 26, or can a court ignore the requirements of Rule 26 and impose sanctions under other authority for the same violation of Rule 26? Issue 4.
No.
Rule 26, Rule 26, Rule 26, Rule 26.
Holy shit, it's like counting sheep. Please stop.
Can a family court award $150,000 in fees under ARS 25-324 or ARS 25-809G without making specific factual findings that a party's unreasonable conduct caused the other party to necessarily incur reasonable fees? Issue 5. When a trial judge considers ex parte evidence, such as anonymous social media posts made after a hearing, which are not admitted into evidence, and the court makes an adverse factual finding based solely on that extrajudicial, that's always hard for me to say, extrajudicial evidence, is the judge obligated to recuse, and if recusal is denied, is that subject to harmless error review, which requires a separate showing of actual prejudice, or is it structural error requiring automatic reversal without any further proof of prejudice? No, shut the fuck up. Next. Material facts. Laura was not pregnant. The first dispositive issue is purely a question of law. Did the trial court apply the wrong legal standard when it ordered Laura to pay $150,000 in sanctions for for filing a pleading that violated Rule 26 without following any of the procedural requirements of Rule 26? Resolving this question of law involves no factual disputes. Even if every adverse finding of fact against Laura is true, the lower court still erred as a matter of law because they misapplied Rule 26. This court
Everyone
has
except for
never.
you misapplied Rule 26.
Yep.
I mean, for fuck's sake, man.
It's like he knows this all better than all of these other people.
All the judges, all the lawyers.
Yeah.
The one that worked on the rule in the first place.
Exactly. Who wrote it, who deal with it every day.
Hey, let's go fight with someone on Reddit.
This court has never interpreted the Rule 26 safe harbor, but countless federal courts have done so with its federal counterpart. Decades ago in 1993, Federal Civil Rule 11 was amended to add a safe harbor exactly like the one in Rule 26. In the ensuing 32 years, federal courts have consistently held if the safeguards of Rule 26 are not followed, sanctions are unavailable. This is true even if the underlying pleading was frivolous. See Holgate versus Ball. Oh, fucking Holgate again. We must
I'm so
reverse
tired.
the award of sanctions when the challenging party failed to comply with the safe harbor provisions, even when the underlying filing is frivolous. Arizona trial courts concur. Rule 11 sanctions are not available to the party that fails to strictly comply with the requirements of the safe harbor provision. Gallagher versus Serrano, a law office 2020. Footnote 1, unpublished authority cited for persuasive value only. Oh, yeah, okay, it's from Lexis. Of course, it's not published yet. You little bitch. Ready for the next page?
Don't talk to me like that. Yeah. One sec. There we go.
Because the error here was procedural/legal, the facts are essentially irrelevant to the question of Rule 26's application. However, some background detail is helpful for context. As such, a condensed summary of the facts is offered. Oh gosh, thank you so much. More bullshit. Background. A 2-hour evidentiary hearing was held on June 10th, 2024. The transcript is provided in the petitioner's appendix as Exhibit B. The basic facts come from that transcript. Laura claimed on May 2023 she had a one-night sexual encounter with respondent Clayton Echard. 11 days later, Laura took the test that showed she was pregnant. Clayton denied the sexual intercourse occurred, but he initially acknowledged in writing that there was sufficient other sexual contact that pregnancy was a possibility. Not
I wish they would
exactly.
stop dumbing themselves down to believe that, but okay.
Months after the case began, with both parties proceeding pro se, in mid-December 2023, Clayton retained counsel who accused Laura of fabricating the pregnancy. Yep, Clayton also did as well, before December 2023. Clayton's counsel threatened to seek sanctions under Rule 26. Days later, Laura retained counsel, and on December 28th, 2023, Laura invoked the Rule 26 safe harbor by moving to dismiss with prejudice. Appendix Exhibit C. In her motion, Laura explained, petitioner is not now pregnant with respondent's children. Here, there is no paternity or maternity to establish as petitioner is no longer pregnant. Accordingly, this case must be dismissed. Despite Laura invoking Rule 26 safe harbor, 6 days later, on January 3rd, 2024, Clayton moved for sanctions under Rule 26, Exhibit D. That motion cited no other authority other than Rule 26 as grounds for sanctions. You can scroll.
Sorry, my mom's blowing up my phone.
Okay. Is everything okay?
Yeah, I just didn't answer a text.
Oh, mine is the same way. She's always like, I need to call the police to make sure you're okay. And I'm like, dude, I was
Princess, hello.
watching a movie.
Jesus Christ.
Nice to know someone cares, but Clayton's motion failed to comply with Rule 26's new procedural requirements in multiple ways. First, Clayton failed to provide the written warning required by Rule 26C2B. Second, Clayton failed to attach a copy of the written warning to his motion as required by Rule 26C3D because no such warning was given. Third, Clayton filed the motion before the 10 business day safe harbor period required by Rule 26C2B lapsed. Fourth, Clayton filed the motion despite Laura promptly doing exactly what the safe harbor permitted. She withdrew the alleged violation. The trial court found Laura's petition violated Rule 26, Exhibit D. Despite this, the court held compliance with the safeguards of Rule 26 was not necessary because fee sanctions can be ordered under other authorities, ARS 24, 324, or 25, 809G. And those other authorities do not have the same safeguards as Rule 26. The Court of Appeals affirmed that logic, Exhibit A. We scroll to number 2.
Yes. Your Majesty.
Thank you, subject.
Stop it. I like that. That was kind of okay. Stop it. So
We'll
tired.
continue. We'll continue after the stream.
Please don't. I just want to go to bed.
I'll just send you like a voice note for the morning.
I'm really not that into it. I just want to sleep.
Just want to sleep. 2 additional facts relevant to structural error. After receiving the trial court's post-hearing ruling, Exhibit E, Laura noticed a key factual finding was not based on any evidence admitted at trial. Rather, the finding appeared to have been copied from the social media post made by an anonymous third party on the internet after the trial concluded. Specifically, in summarizing the trial testimony of Clayton's medical experts, Dr. Samantha Deans, the court made the following findings. Dr. Deans testified that Planned Parenthood does not accept anonymous patients. They don't accept patients using an alias. Patients are required to provide a government-issued form of identification. She further testified that Planned Parenthood is not open on Sundays. One petitioner testified she sought care on July 2nd, 2023. That's Exhibit E. You can scroll.
You're not gonna yell at me a little, or
Subject. The specific finding that Planned Parenthood is not open on Sundays was attributed to the trial testimony of Dr. Deans, but as a trial transcript, Exhibit B clearly shows Dr. Deans said no such thing. Instead, it appears as the only basis for the court's findings was anonymous social media post published online after the trial concluded, Exhibit F. Upon seeing this, Laura filed a notice of change of judge for a cause, Exhibit F, arguing that the trial judge's review and consideration of extrajudicial evidence social media posts published on the internet after the evidentiary hearing was sufficient to show bias and prejudice within the meaning of ARS 12-4095.
I don't see anything about any daddies in here.
Right.
Disappointed.
Disappointed.
What did I do? Stop it.
What?
Where did I go?
I think you need to go down. Wait, the presiding judge, maybe up a little bit.
There it is.
Yeah. The presiding judge denied Laura's notice, concluding with essentially no explanation that these facts failed to show by a preponderance of the evidence that Judge Motta's findings that Planned Parenthood is not open on Sundays reflects bias or prejudice against petitioner. The presiding judge also found any misconduct was non-prejudicial because the issue of Planned Parenthood's business hours was of little to no importance given the rest of the findings on the July 17th ruling, Exhibit G. Those findings were affirmed by the Court of Appeals, which rejected Laura's argument that the judge's review of extrajudicial evidence constituted structural error requiring automatic reversal. The court further observed, while a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias, apart from any structural error claim, the critical inquiry that would require a reversal is whether the conduct demonstrates an extrajudicial source of bias or deep-seated...
I'm sorry, what was that?
Scroll. Please.
Okay. Yeah, no, you're where I'm at. Where I'm at right now. I can hear it.
Extrajudicial evidence constitutes structural error requiring automatic reversal. Is that where I'm at?
I don't know. My brain's broken.
Well, the trial court's reliance on extrajudicial... No, I already read this. Information may give rise to a claim of judicial bias. I read that. Okay, source of bias or deep-seated favoritism. There it is, in the middle of the page. The appellate court concluded that Laura failed to meet the standard and that the issue of Planned Parenthood's business hours was not prejudicial. In reaching these conclusions, as explained infra, the Court of Appeals misapplied Arizona law and made it the same legal error that was reversed by the Kentucky Supreme Court, Marchese versus Abersold. Jesus. Finding review of extrajudicial evidence in family law matter constituted structural error requiring automatic reversal without showing a prejudice required and reversing Court of Appeals decision, which held harmless error review applied. Reasons why review should be granted. 1. No published Arizona decision controls this point of law. Rule 26 is essentially brand new in family court. On August 30th, 2018, this court ordered sweeping changes to the rule of family law procedure, CR 170054. You can scroll.
Yes, ma'am.
Thank you. This was the first overhaul since the family law rules were created in 2006. The change was so significant, Respondents' Counsel even shared a helpful article about it, observing the update was needed to confirm those rules to modern usage. So footnote 2, as the original article notes, the purpose of the change was to conform those rules to modern usage. And then we can see he typed conform, but it says confirm those rules. So he used the wrong word. I don't know why he did that. You can scroll.
Oh no, maybe it's hard for him, like extrajudicial.
Extrajudicial notice. Like they got like 20 freaking times. When it changes the rule 6 years ago, this court fundamentally altered the process for seeking and avoiding sanctions in family court. Unfortunately, because Rule 26 is so new, and because it contains requirements not present in the old rule it replaced, there is no published authority from this court or from the Court of Appeals interpreting the safe harbor requirements of Rule 26. Scroll slab.
Everybody's like standing on a scroll slave. Move the mouse, bitch.
I read it as slab.
I mean, that is all I'm good for right now. I'm honest about it.
Scrolling.
Are we good here?
That mouse wheel scrolling. Okay, I'm just gonna start at number 2. This case involves important questions of law which were incorrectly decided. The lack of any published authority involving an important new rule is reason enough to grant review. But another good reason exists. The Court of Appeals decision was egregiously wrong. The Court of Appeals flatly ignored more than 30 years worth of federal case law interpreting the now substantively identical federal version of Rule 11.
I read a word correctly.
Thank you.
I'm starting to feel alive again.
Substantively.
Maybe I don't need to go to bed.
It's just a lot of schwas there. Substantively. Which Rule 26 was expressly modeled after. A schwas, the sound. Like, anyway, doesn't matter. Indeed, the Court of Appeals refused to even discuss any of the federal authority supporting Laura's position, concluding wrongly that it was not well grounded in fact and or law. Clearly, the opposite is true. Indeed, the Court of Appeals errantly affirmed using the logic of process of the outdated and now abrogated Rule 31. That error was directly invited by Clayton, who improperly cited outdated Rule 31 authority. Scroll. Slave?
Yes, master. Sorry, let me try that again. Yes, master.
Higher. That.
I'm so tired.
That error was, we should be done soon. That error was directly invited by Clayton, who, authorities such as Grow versus Grow, a case decided before the 2019 rule change. Grow involved Rule 31, not Rule 26. Because of that invited error, the Court of Appeals improperly ignored helpful and plentiful federal cases interpreting aspects of Rule 11, which are functionally identical to Rule 26. In refusing to accept guidance from the federal courts, the appellate court also departed from Arizona's longstanding tradition of doing exactly that. See James Cook and Hobson, Inc. versus like whatever the fuck that is. Arizona courts consider a federal court interpretation of Rule 11. To help shed light on Rule 26 function, in her appellate briefing, Laura cited extensive federal case law describing several key aspects of Rule 11's purpose and application. First, when the procedural requirements of Rule 11 are not followed, sanctions cannot be awarded even when a pleading violates the rule. We must reverse the award of sanctions when the challenging party failed to comply with the safe harbor provisions, even when the underlying filings are frivolous. That's a whole gate. I'll see also Westerkamp, denying sanctions when procedural requirements of rule were not met. Second, when the procedural requirements are not met, a court cannot sua sponte fix the error by converting a defective Rule 11 motion to one made under some other authority, such as the court's inherent authority. This is not permitted because doing so would destroy the safe harbor's purpose. We scroll. See Radcliffe versus Rainbow Construction. Rejecting this.
Hell yeah.
Yes. I was thinking of a joke and I couldn't come up with one. Rejecting this approach.
That was the best I could do with the rainbow thing. So I got nothing. I'm so tired. Did I say that yet?
Tired? You're tired? I'm surprised. It would render Rule 11C1A safe harbor provision meaningless to permit a party's non-compliant motion to be converted automatically into a court-initiated motion, thereby escaping the service requirement. Similarly, because the point of the safe harbor is to encourage litigants to withdraw claims without fear of sanctions, a party cannot seek sanctions after a litigant has timely offered timely offered to dismiss his case with prejudice. Doing so completely ignores the purpose of the requirements of the safe harbor provisions. Corner Edge Interactive LLC versus Johnson 2021. Third, Laura cited extensive authority holding when a party threatens Rule 1126 sanctions, as occurred here. The accused violator has an absolute right to withdraw the offending pleading before punishment can be imposed. If corrective action is timely taken, that's a weird way to say it, as it was here, sanctions cannot be ordered. See Barber versus Miller, 1998, reversing sanctions where alleged violator was not given the opportunity to respond to the sanctions motion by withdrawing his claim, thereby protecting himself totally from the sanctions pursuant to
You have to say it.
scroll, bitch.
There it is.
That motion. The purpose of the 1993 amendment was entirely defeated. An award of sanctions cannot be upheld under those circumstances. Emphasis added. To the extent Clayton cited any responsive authority at all, it only further supported Laura's position. For instance, Clayton cited dicta from Carancini, Nation Star Mortgage LLC, 2024, which implied but did not decide that sanctions for a groundless pleading might be available under other authority, even if Rule 11 safeguards were not met. But Carancini involved an award of $50,000 in sanctions imposed after the alleged violation was resolved by dismissal of the complaint. Rather than affirming the sanctions on alternate grounds, as Clayton specifically argued was proper, the appellate court reversed the award of sanctions. It did so because in that context where sanctions were requested after a violation was cured, the violator was not afforded an opportunity to remedy the sanctionable conduct and avoid the sanction, Carancini. The exact same error is present here. The trial court imposed a $150,000 in scroll, please.
Before I do that, I just want everyone to see this freeze frame. Hang on.
That's funny.
Because he's talking about Omar again in this video.
Actually, I think he looks like Donald Trump right there. Oh, always.
Think about Donald Trump and Omar's dick. Thank you.
No. Oh, God. No.
You started this.
No. Now I'll never be the same. In the sanctions for fees which Clayton incurred after Laura invoked the safe harbor, by allowing the case to continue for 6 months beyond that point, the trial court deprived Laura of her absolute right to the safe harbor. The court's machinations also disregarded this court's final rulemaking authority when it abrogated Rule 31, which would have been permitted this outcome, whereas Rule 26 plainly prohibits it. The fact, okay, we're almost done. Jesus. The fact that the fee sanctions,
like a 15-minute thing.
15. I just said it was 20 pages. I'm trying to read fast.
No, I meant the stream in general.
Oh, well, this will drop literally right as we're about to get off. Oh my God. Okay. The fact that fee sanctions could have hypothetically been awarded under, it said it in here. Other authority does not change the result. Here, Clayton actually threatened Laura with Rule 26 sanctions. Then he actually moved for sanctions under Rule 26. Those are facts, not hypotheticals. Applying Rule 26 correctly, the moment Clayton threatened sanctions, the rule gave Laura the absolute right to withdraw her petition within 10 business days, which she did, thereby expeditiously terminating the proceedings, or at least trying. Scroll, please.
I'd like to terminate my consciousness. Jesus.
You're welcome.
Fuck you for that. Wait, okay. Where were you at?
Go?
What did I do?
Or at least
good.
Oh God.
Okay.
We're
Just start there.
Okay. By refusing to allow are we there? Is that the right page? By refusing to allow Laura to take the safe harbor, the trial court did exactly the opposite of Rule 26 was adopted to achieve. The court needlessly forced the parties to spend 6 additional months litigating a moot issue. When Laura told the court she was no longer pregnant, the issue of paternity clearly became moot. Of course, Clayton argued he still had a claim for fees, but Clayton was pro se and incurred no fees, or at least not $150,000 in fees from the commencement of the case until the time Laura moved to dismiss. To the extent Clayton incurred any fees, meeting and conferring with Laura's counsel about the issue of sanctions before Laura moved to dismiss, those fees were precluded by the effect of the safe harbor. A party who takes the safe harbor is rewarded with safety from sanctions. You could
Didn't we
scroll
say
there.
that already?
Yeah, like too many fucking times. In my opinion. Oh, you have a super chat.
Oh. Just Ricardo, thank you for the 5. Serious question. Should one ever be able to sue with absolute safety like these monsters are trying for absolute shields, and that's not right? I mean, if you're asking me, I don't think they should be able to, but I mean, I'm not an attorney.
I think that like Omar has said something about that, like how you can't just bring frivolous lawsuit. It has to be filed in good faith.
You and I would have sued each other about 4 times by now.
Try 69.
Fuck you.
Oh, okay. Let's go. The lower courts misapplied Arizona law regarding judicial misconduct. Although it is not necessary for this court to reach a separate question, the Court of Appeals also improperly decided a separate issue of law involving judicial misconduct. As noted above, the trial judge made a key adverse finding regarding the business hours of Planned Parenthood, but that finding was not supported by any evidence admitted at trial. Instead, this finding was clearly copied from social media posts made on the internet after the June 10th evidentiary hearing concluded. The Court of Appeals held in this context, harmless error review applies rather than the stricter rule of structural error. Exactly the same thing happened in Marchese versus Abersold 2017, a case involving a family court proceeding in which a trial judge considered extrajudicial evidence regarding the criminal history of a party.
I'll be right back.
Okay. Yeah, scroll. No. Yes. Oh, there we go. Yeah, stop. No, party. Oh. Anyway, I disagree with what he said. I don't think it's thanks. It's definitely not exactly the same as Marchese versus Abersold. He's a fucking lunatic if he thinks that, in my opinion. In Marchese, as here, the Intermediate Appellate Court held judicial misconduct involving review of ex parte evidence is subject to harmless error, requiring proof of prejudice. Just as this court should do, the Kentucky Supreme Court granted review and reversed holding. We conclude that the trial judge is undertaking to obtain and use as evidence extrajudicial information regarding relating to a party in the case. Sorry for the mess ups, caused her disqualification from proceeding further as the presiding judge in this matter. Her failure to recuse at that point was structural error, undermining the integrity of the resulting DVO. Because structural error supersedes harmless error, we need not review the finding of the Court of Appeals that the error was harmless.
So the lady knocked on my door and she was here to pick up laundry. She meant to knock on the person next to me, which, was unfortunate because I told her she could take mine. But I guess that's not how it works around here.
That's funny.
Yeah. Anyways.
Okay, so Marchese. Here, without any discussion, the Court of Appeals rejected the Kentucky Supreme Court's holding in Marchese. In doing so, the court also misapplied Arizona case law, which reached the same result as Marchese. See State versus Manuel, 1989. Holding when a trial judge conducted ex parte interviews of victims in a theft case, judge was required to recuse and defendant was entitled to resentencing before a different judge without any showing of prejudice. Conclusion, finally. The word limits of Rule 23 do not provide room for a complete discussion of all other issues, but for the reasons stated above.
23? Are we talking about 23?
Rule 23, it must be the rule about limiting how many words the appeal can be.
Oh, I was so fucking confused. See, you said 26 so many times.
Right.
When did you say 23?
23 out of left field. The court should further order supplemental briefing and oral argument and should reverse the judgment below. May 29th, 2025.
You have to be such a pervert?
Yes. After hours schnitzel.
I mean, this is pretty much during all hours, but
and that's okay. So Laura gives notice that she seeks an award of attorney's fees incurred pursuant to ARS 25-809G, permitting in any paternity proceeding award of attorney's fees, deposition costs, appellate costs, and other reasonable expenses the court determines were necessary. Zero, zilch. Fuck off, motherfucker. That's what you're getting, in my opinion.
Yeah. All right. I think we're not going to go through all these fucking exhibits.
No.
Let's see. What were these?
So the memorandum decision, trial transcript from June 10th, petitioner's motion to dismiss, respondent's motion for sanctions under Rule 26, under advisement ruling, that's Mata's ruling, notice of change of judge for cause, order denying change of judge, Arizona Family Law Procedure Rule 26. So he's including the rules so they know what the rules are. Rule 26 and Rule 31. Then we can scroll if you feel like it. Is that? Oh,
You
that's
know,
it. Okay.
no.
Yeah. So we've
No.
seen all of those things, I guess, except the Rule 26 and 31 definitions. Maybe no one has ever submitted that.
Randomly pick 2 pages and just read those to see like a surprise. That sounds like a nightmare, dude.
Type 69, page 69. We'll do
I-
one.
Oh, I hate you so much. All right.
Ooh. Pick a sentence.
Oh, me?
Yeah.
How about the first one?
Oh, now go all the way to the bottom.
I don't understand. Then scroll all
Trying
the
to-
way down.
Yep. That's one of the part of the first section.
So many of these people trying to tell me what to do today, man. Everyone wants me to scroll.
It
Scroll,
said it up
Lauren,
at the
scroll.
it said it at the
Scroll,
beginning of
Discord.
this
You just
page.
think I'm a piece of meat.
No, scroll up. It says it there.
What?
It says now go all the way to the bottom. There should be an R. Keep going if you're able to.
What are we looking at?
Right, this third sentence.
Okay.
I was reading it and you thought I was telling you to go all the way to the bottom. Oh,
Bruce is like, I had it with my shit. No, chat's crazy.
it's
today.
oh, Jingris.
I'm too
Oh,
tired to read
right.
it.
It's tiny. I'm blind. I'm blind.
Oh,
Right
you're
in
actually
the
reading
middle.
the page. Oh my
Yeah.
god. Wow. Gotcha.
Petitioner faking ultrasound. Yes, that happened.
Sorry, that's not funny.
No,
It's not.
no.
I'm just really tired.
In and of itself, it's not funny.
No.
In the context of all of this.
Which ex? Greg Gillespie. Okay, we're done here. I'm done. We're done.
Because Greg hacked
This is
my
over.
email.
Oh my god. Of course he did. What is this transcript? It's a trial transcript, yeah?
Transcript.
Yeah.
Yeah, from June 10th.
Oh, thanks, Julia. Good to see you. I think I got through all of these, yes. Wait, did I read this already?
I don't think so.
Fake Laura Owens, thank you for the 2. Good faith, what's that? It's the thing you say in Grace before you eat the Domino's pizza you order every night for your own writing. I guess that's what that is. But you're asking the wrong person. Okay.
So someone asked, do you want to say the name of her lawyer? Someone asked.
I don't care. I don't remember it. You go ahead.
It's Josh Colesrud.
Yeah, I did not retain that or anything else that happened tonight. Tonight for you, this afternoon, this morning for me. I'm gonna forget this conversation ever happened.
Well,
Because
you'll
I'm
get a
so
nice
tired.
reminder when you wake up.
I'm sure I
You'd
will.
be like, I did that.
I mean, that wouldn't really shock me, any of it at all. Especially the fumbling over my own words while completely sober.
Hey, tiredness can feel just like that.
It actually does. I feel quite drunk.
Mm-hmm.
Like I haven't felt this drunk in a while.
Oh yeah, so the docket says Sandra, who is a part of this law firm, but when Bianca asked at the courthouse today who the lawyer was, she was told Josh, and then Josh is also the one who interviewed, obviously, on that video you played. So they could be working on it together, or maybe she's actually going to be repping her in the case and Josh is speaking on behalf of the law firm. We're not sure.
Yeah. Omar says, is Lauren on a gummy? No. No, I am not brave enough to smuggle gummies into Australia where it's totally illegal everywhere. So I'm not a lawbreaker. If I get sent to jail, it will be because of my mouth.
You're a heartbreaker.
Actually, no, it's usually the other way around.
Maybe you
That's
break their heart
unfortunate.
first. They just get bitter.
They what?
What? They just get bitter. You break their heart first, and then
I don't though. I never do
then
that.
well, but maybe you do, and they just don't say it. Not good communicators, obviously.
No, that's definitely true. But you know, can't imagine what I would have done to warrant. You know what? We're not going to get into that right now. God damn it! This isn't a fucking therapy session.
Oh, guys, do you want to do that? We could do therapy with Lauren and Schnitzel. I'll be your therapist.
What is that for me?
Working through your feelings.
Those are terrible. I put those away.
Put those away.
If I go to jail, it's because of my mouth too. Thank you for the fake Laura Owens. I think we're thinking of different things there, but yeah, I get what you mean. Yeah.
Oh my god.
Did the Uber driver get into your DMs? He did text me the next day. He's a very nice man. He is not hitting on me.
Wait, but how does he get your number?
He had it because I was texting him. I was like, "Hey, can you pick me up and take me to Omar's house? Hey, can you bring me from Omar's house back to the hotel all the way by the fucking airport?"
Oh my god, so
and
he came back and picked you up.
Yeah, both times. And then he texted me the next day because I'm going back there on my way home, and he said that I could, tell him if I needed a ride anywhere. Obviously, I'd pay him for it, but he's going to Navy boot camp, so I don't know if he's going to be around much longer.
Oh,
yeah, right?
Interesting.
Cool dude.
Well, hey, you only live once.
What's up,
Maybe you
Ryan?
can take him up on that ride.
Ryan may or may not be watching. Have fun.
Did you tell him about your channel?
Yes, I did.
I bet he's watching.
We talked about a lot.
Did you tell him about your
We
schnitzel?
spent probably combined from all that, probably 6 hours in the car together.
Oh my god.
Yeah.
That's better than sitting in silence for that long.
I disagree. But it wasn't bad.
But it wasn't bad.
Right.
Oh, so funny.
Yeah.
Well, I'll hear more about that when you're not so tired or live.
Yeah. Well, Omar, I don't know if Omar is going to do anything with this, but he'll probably do a much better job than I did if you guys go over together, because I just sat here and I barely scrolled the mouse when you yelled at me.
You were a great listener.
Actually, no, I zoned out a lot. And then I was texting. So I really did not. This was not my best work.
Scrolling and texting
on two separate things.
Well, it's good. People have they can listen through to the filing and
that's true.
See what they think.
You usually do this anyways, right? With all these.
I do, but maybe now I don't have to.
Yeah, well, I was just gonna say if you do, I will use it to fall asleep from now on.
Thanks. Compliment? No, I don't know.
You're welcome.
You're welcome.
Don't know what that was.
I like it. It's the sass.
It's never coming back.
It went away with all your feelings.
Oh, so it's in the closet.
But you're not. And that's the important part.
Not today.
You were on that Uber ride.
Just the first one. I needed a ride home.
You played the part. Maybe.
No, I stopped doing that a while ago. Been a good 10 years. More.
This side's better.
What's better?
The side of the ladies.
The gay side. Yeah. No, it's all pretty terrible.
Ladies are, I'm married to a guy, but ladies are better in general.
No, I don't get women. I don't get them.
I don't know. There's a couple at the end of my street that's two married women, and they're in their.
No, we all know each other.
Oh well, they're in their late 70s, early 80s, and
so they're my type.
I love them so much.
Okay.
Yeah, so they're my type. Okay. Well,
ladies are awful. You don't date them. Hey, man, I agree. It's got to work out sometime, right?
It will. Absolutely.
Oh, that was I didn't actually mean for you to answer that. I just said it out loud and then I just kind of went to sleep there for a second.
Well, I ansed it.
I feel
I'm just your conscience right now.
I feel fucking high right now. This is ridiculous. I've had no substances.
Just exhaustion. Go to sleep.
Yeah, someday. Hey, Lauren, do you know my sister? Oh, so she's a gay too.
So she's a gay.
Omar says, I'd rather be gay, but I like women too much. Omar, you have a wonderful wife. I like her better than you. Why are you saying that? What is wrong with you?
I'd rather be gay.
Well,
I
I'm telling you,
need
you
more
said that.
information on that.
Ridiculous. I said the same thing once, so be careful.
Just wish it into the universe. It might come true.
Yeah, that's what happened.
That's what we
You're
need.
weird.
We need Laura to be a lesbian, and then she can never get pregnant.
No. You keep her out of the pool. That's not happening.
She's not welcome here.
There's like 3 of us left, and one of them cannot be Laura Owens.
Omar says men are easier. This is gonna have to be a conversation for a different day.
No, I agree with that. I agree with that. But like I said, Omar has a wonderful wife, so I don't know why he is talking like
Yeah.
that.
What the fuck, Omar?
I would sit here and insult you some more, but I can't come up with anything creative. All I have are bad words at the moment.
Schnitzel is triggered. Women are better than men, damn it. I would say men are simple. I wouldn't say they're easier.
Both.
They're simpler.
I was on that train once, So
Oh yeah, I heard.
I told you. Unless you heard it from someone else, in which case we gotta talk.
No, I heard it straight from your mouth.
Mm-hmm.
Mm-hmm.
I don't keep a lot of secrets unless they're other people's.
Just hide the feelings away.
Oh, that's right, Omar. We love you too. But Omar, David has some stuff to say to Slash about you in his new video. I guess he forgot that he wrote your name down in his Dead to Me diary. And I don't know what's going on with that. Anyways, I read part of the transcript. I did not watch it. I don't think I can bring myself to do it, but I'll just read it.
Yeah.
So, I hate that I'm probably going to go watch it. I understand the curiosity. Remember, at one point I did that too, and then he tried to sue me for showing it. So,
You hurt his feelings.
I was actually super nice to him. I was like, I don't want to knock on his personal life. I'm going to skip over the part where he's like telling his life stories because I don't want to take that away from him. I was super, super nice to him. I remember that. And then he was stupid enough to do that thing where he waited till I had started already. Then tried to register with the Copyright Office. Then took a legal action against my channel. And then tweeted about how he actually didn't watch the thing that he struck. So, how stupid are you? How stupid are you to actually do that?
Let me count the ways.
To go initiate that process and then be like, oh, but by the way, let me put in writing here right now publicly that I didn't actually watch the material that I'm striking.
So
Fucking
dumb.
moron.
Yeah.
I was here when that was happening too. This is the last time.
Last time you were there, yeah.
Yeah. Huh. Guess it's only been 6 months, huh? Feels like a lot longer than that.
It does. Feels like 9 months, a year. Feels like six
What,
and a
like 3 or
half.
4 years?
6.5 months.
What? Is that supposed to have some kind of significant? Did I forget our anniversary? What's going on here?
No. You remembered. You remember?
Did I?
We did that thing.
That's right.
Yeah.
Okay.
Yeah. I see it was just as good for you.
I was asleep. I'm sorry.
What? So I didn't have permission? What are you implying here?
No, you had permission. It's fine. You have my full permission. I just don't want to be conscious.
Oh my god.
What would your husband say?
What a chat. He would laugh. I think.
Okay, well, he's just really cool.
No, we've known each other since we were 16.
Oh yeah.
So it's been a while. And I think think everything that needs to be known is known, as in my
Oh.
sense of humor as well.
Yeah, I got you. Oh my God.
Oh man.
Somebody said "Gay Panic." Did I forget our anniversary? "Gay Panic" is the title of my memoirs.
Gay panic. That's great.
All right, I need to force myself to log off the computer now because I have to go to sleep a little bit.
Yes, do it.
At least
Take
for
it
an
out.
hour or two. And then I'm gonna go do something else.
Nice. You should share a
I'll
picture.
be. I will. Just let me hang on. I'm trying to read this at the same time as I'm talking, and that's a bad idea right now because I have half a brain. Yeah, let me sign off and get some sleep, and then I'll do something later because it'll be middle of the night for you guys by the time I have time to come back here and work on anything else. So everything that I'm gonna do is probably gonna be pre-recorded, not live stream, but we'll see
Mhm.
for the rest of the week because there's always a lot going on with Justin Blake too. So
Yeah.
it's just gonna be a lot to juggle in different time zones, but I'm gonna do it.
Let me know if you need any help with anything.
Help me.
Right
all
now,
it.
please.
The whole thing.
Be me, please.
No, that's too much. Stay safe, Lauren. Get some rest. I will do one of those things. I'm not going to tell you which one. Lauren is slowly sliding down. I've been doing that for a while. Half hour.
We can like just barely see like your chin.
No, I got like all the way over here at one point.
Go lay down.
Just enough for you to see that my eyes are still open. All right, guys. I gotta go. We need to get Lauren a personal assistant. Okay. You're paying for it, though. And she doesn't get to scroll. So I still get to scroll. Yeah, it has to be a she. I don't want a dude assistant.
What about your Uber driver?
He's a driver.
He's a driver.
Yeah. I only have to talk to him when I'm in the car. If I have an assistant, I have to talk to them all the time. I don't want to talk to never mind. I don't know. I just like, it'd be too distracting. It'd be kind of like me hanging out with Omar all day while I'm trying to work. You know what I mean?
Mm-hmm.
I just can't do that. Nothing would get done.
Yeah, that would be tough.
Nothing. Ever.
You can never be friends with your boss.
Yeah.
Not real
Sure.
friends.
Yeah, I tried that. Not a good idea.
Mm-mm.
Mm-mm. I'll be your assistant. Nice. I don't have any money to pay you, but okay. I spent it all on this hotel room.
Oh,
if
is
you
it
want-
the same? Is it the same hotel you were in before?
It is. I'm not in that giant suite like last time, but yeah, because it's not
Nice.
my birthday, so
The
no
regular.
one threatened to sue me this time around. So I guess I just didn't want to splurge.
No, that's nice that like it was a good place and you can go back and make
I'm here every time. every time.
feel comfortable there. That's
Same-
great.
Same hotels every time. Yeah, it's right here in the harbor, and then I can try to open that. Hang on, you're not gonna be able to see it probably, but I'll try to open it. Wow, that was a bad idea. Yeah, I don't know if you can really see that. No, it's too bright.
It's we see just white.
What if I like cover myself
Oh,
and it's focused on
That helped a little bit when it was on the top.
Won't work. Hang on. Oh, like that?
Yes. Yeah.
You can kind of see. Oh,
Oh, beautiful.
yeah, it looks better at night.
Wow.
I'll take pictures.
Cool. Where's the opera house in comparison to where you're? Isn't that like a big famous thing there?
Yeah, I'll see that when I'm on the boat.
Okay.
Oh, I'm so tired.
Can I end the stream for you?
Please
I don't know if I can.
end it. Please end it for me. I can't do it myself.
Do you remember when you just left and forgot to end it and just left me
Bye,
here?
everyone. Yes, I did. That was on purpose. Goodbye.